which was, oh,
Go
which was
ahead.
kind of an
This is good.
yeah, which was kind of an interesting approach because she intentionally didn't notice me and she got her way because I wasn't there, right? So she
Absolutely.
got an ex parte to stay the lockout until the hearing for the motion to vacate, which apparently was for today. And yesterday she called me. This time she did call me because she knew that I was going to find out eventually that she was going to have an ex parte for a continuance of the motion to vacate. And I said, well, I still never got served on any of your documents. I really don't know what you're talking about, but all right, I'll see you tomorrow. So I went today, and so we get there. It's a pretty full courtroom, and she hands me her papers that I never got served before. So obviously the service would have been wrong in the first place. And when I looked at her papers, I don't normally, I'm not usually in the UD court, but since all of our, hearings that we've had in our classes, it just became so clear. I just got to observe firsthand. And as soon as I read her motion to vacate, I thought, oh, piece of cake. I've got this and I can win this, no problem. And so I was like, chalking up in my mind going, okay, she didn't serve, she's out. She never served me last time, out. Court has no jurisdiction, can't really go there. I already won my judgment before. And I'm thinking of all of the things that I could win on. And then even if he did allow her to elaborate and argue, then I'm looking at her motion to vacate saying, she doesn't even make any of these elements. I mean, not even close, right?
Yeah.
But so anyway, so as we're sitting there and we're doing the standoff, she's saying, as if she's got some standing or something. And she goes, well, I'm just going to, we'll just let the judge decide. I said, yeah, we'll let the judge decide. Good call. We'll do that one. And so then the judge was interesting because he said from the start, he's like, the eviction, this is an unlawful detainer courtroom. Unlawful detainers are the highest priority in all the courts for us to make determinations on and move these cases along. So he said, so if you're a landlord or a tenant in pro per representing yourself, he goes, just to let you know, as a landlord, we expect that you have to know all of the rules, all of the procedures, all the law, and we're not here to help you. So just want to make sure you understand that. And he goes, so you chose to be here without an attorney, so you just have to be ready to know how to handle your case. And then he said, and the tenants, we're not here to protect your position. We're here to look at the law. And he goes, and that's what we'll be doing. He goes, most of the time, we're not going to be making decisions that you're going to like. He goes, but it's not up to me to have you plead and beg or anything else because that's not my position. So as he's saying this, and we start, clearing out the courtroom, and he said, and anyone that can make a stipulation, I can hear that right away, and it'll probably move you through the day, and you'll be here a lot less time. So the next day, about an hour and a half later, she's like, can we make a stipulation? And I said, there's nothing to stipulate to. You just need to move out. And she said, well, can we stipulate that I'll move out? And I said, oh, yeah, absolutely. Today? And she said, I said, you're talking immediate, right? To me today. And she said, well, I don't want to do any of this stuff. And I said, oh, okay. She said, can we just leave now? I said, oh, absolutely not. You called me to be here. We're not leaving. The judge has to, make an order.
Right.
I said, that's what we're here for. Yeah. So anyway, so we ended up, going back and forth. And so I went in there, we made a stipulation, and I go in there. And then as soon as it got in front of the judge, I said, oh, yeah, she's stipulating to move out immediately, but today. And he goes, today? And she's like starting to cry and looking at him like, he goes, no, I don't think you have a quite an agreement yet. Because you might want to go fix your agreement up a little bit better. I don't think you have an agreement. We'll put you on the second call. I'm like, second call? No, not that one. And he goes, no, just go and redo it and come back. And so he goes, you can't have your settlements in the open courtroom. I said, okay. So anyway, we eventually when I came back in the room, we did get to agree she's going to move out on Tuesday, and then I give her 10 days to coordinate the rest of her stuff. So, she agreed that she won't file any more motions of any type and all of that. And I wrote it all up and got the court order. But what was interesting and what I was thinking of when we're listening here right now is just watching the judge on two specific hearings that I witnessed, and the people that don't know the law, how that we walk in there, and I've done it and we've all done it. We walk in there thinking we can talk about something that we think is related. And it's so far off. Like, I was just watching the judge let them, speak to whatever, but he's just holding his ground. He went both directions. One of them was for granting the motion for summary judgment, and the other one was denying it. And it's just really interesting to listen to what they were saying and watching. And it just became so clear on the narrowness, like you were just saying, the very narrow question that the judge is weighing against versus what somebody thinks that the judge is weighing against, or what one would want to plead to.
Right.
So just from all of the, just all what we've all gone through in all this time, it was really amazing just to have the clarity that came about. Just watching, I just thought, oh my gosh, am I finally like the light bulb going off? It was so clear. The same as when I first looked at what she was saying. I just felt like at peace, like, oh, piece of cake, I've got this 100%. And then when I was listening to the arguments, I'm like, okay, they just don't know. Their arguments have nothing to do with what he's weighing against at all. Right. And he kept going back and pretty much saying what he was weighing against for the most. He goes, well, there's triable issues. And another thing that was interesting, and this kind of caught me off guard, is there was one per defendant who had filed the motion for summary judgment.
Wow.
And it was denied, but she had a special appearance attorney speaking to one of the arguments that he wanted to raise through. And she was standing there, and she was also speaking to the court, and there was an attorney on the opposite side. And they started to object that she's per per, so she can't have an attorney when she can't speak when the attorney. And so then the attorney went on saying, well, I'm a special appearance only, so she can speak. And so the judge actually allowed the full argument from both of the parties. And it just made me flash on, what we normally see is that hasn't been the case.
Yeah,
right?
you can, if you have a special appearance attorney, the judge, you're still represented by an attorney, and they won't let you. There's some judges that will not let you talk at all. No, you got an attorney. If you have a question, ask your attorney. But that's why I've already talked to people. I said, if you have one and you want an objection, you can say, Your Honor, can I have 10, 15 minutes with my attorney, because I'm led to believe that he didn't object to something, or he didn't raise an issue that I believe is crucial to my defense, or, whatever it is that you want to bring up.
But what's the rule surrounding it? Because I just thought it was strange, given that you always, what we always see is that, no, they won't. But is it, he just said, no, Your Honor, she can speak because I'm here as a special appearance attorney, and she can speak.
There's no rule or law that I know of that can allow them to do that, because when you're represented by an attorney, the judges can stand on that. But it's up to the judge. It's his room. It's his courtroom. So he can say, yeah, okay, let her speak. And the other side ain't going to say too much because they don't want to go against the judge. So if he says that, that's fine. And I've seen that happen before too.
Okay, I just thought it was kind of interesting how, normally they don't. They just pretty much keep that. Yeah, but it was really, it felt good to see it from a different light, just observing in person, which is rare these days, and the UD court just to watch, and a judge that was staying within his somewhat, within his boundaries. Yeah, he could seem like a mean judge or whatever, but he was staying within his boundaries of what he was to decide.
Mm-hmm. Absolutely.
So yeah, it was but just the part of the narrowness of the elements, it just becomes more and more clear. Just of all the experience now and listening and noticing the distinction.
Nice, thank you,
And
Darlene. Sounds like you're really having a light bulb moment.
Well-
Go ahead.
Yeah, I mean, it really, it kind of gives you more hope. It gives you hope when you start seeing that if you just real speaking their language more, then and keeping them in that box. I guess it's giving me more hope, because sometimes,
Absolutely.
we might understand certain things, but you go in there and you try to play it out and you feel like, oh my gosh, like making every mistake, somehow never landing it properly. So it was just much more clear. Yeah, you're right,
Nice.
Gavin. It
Oh,
was having
let
a
me-
light bulb moment.
Let me ask you this. Okay, when you were watching that
Mhm.
and she was the defendant
Right. Mhm.
with a special defense attorney, right?
Right.
Now, the other side, the plaintiff was their plaintiff there or was just the plaintiff's attorney?
Plaintiff's attorney.
See, and this is one of the things I talk about though, is that, when you walk inside there, we assume and believe that the person's, all the elements are there. It's like this. If you've ever played chess, there's even checkers. And one side has all their pieces and one side has like a bottle cap and a like a screw for that side. And says, okay. And you say, wait a second, you don't have all your elements there. No, we can play with this. You okay? He's okay. Well, let's go ahead. Then the court moves forward. If you challenge those elements, then they can't move forward. See, remember, always, all courts operate on rebuttable presumption. They assume and believe that what they're doing right now is everything, all the elements are there. You got a special appearance attorney. The other side ain't going to complain and object and do anything like that, but you would do that on the other side. If the attorney of record on the other side, the plaintiff's attorney, he said, well, I'm a special appearance attorney too. Well, then who's the only one that's going to testify to the truth and fact before the matter? You.
Well, that's where this pro se, she was pretty good, because she did say that. She said, Your Honor, I'm the one that has the personal knowledge. So she
Yep.
and a special attorney was on the phone. So he was on the phone and she was there present in person.
Yes. So see, when she
And
said that
that
she has
was-
first-hand knowledge, then she can, that,
Mhm.
and then did they swear in? No.
Honestly, I can't remember, but there was some swearing in on some. There was a few that merged, so I can't remember if she had or
Okay.
not.
Can
Wow,
you determine,
were they
yeah, can you
four-letter
distinguish?
words?
Yeah, I was gonna say, can you distinguish between swearing and swearing in?
Well, there was a lot of swearing going on in some of these that I was watching. I was surprised at the language. Like, wow.
Oh, yeah.
This one guy's saying their full arguments, and then this fucking happened, and then she fucking said that and said fuck you, and I'm thinking,
God.
well, the judge is just listening in, like, okay, and then what?
But you're not, but see, you can admonish them for that, for allowing that kind of language to be in the courtroom to court, because if you're allowing that, then you're gonna allow anything. See, there has to be a certain parameters or that you work
Yeah,
with.
usually a judge will block that off, but it was
Yeah.
coming from the attorney.
Yeah, I know, but even with them,
Of course.
I've seen attorneys really irate, and the judge would tell them, look, you need to be able to calm yourself down, and I'm only going to tell you one more time. If you don't do that,
Oh,
I'm
she
hoping you
wasn't
can
even
tell."
irate. She was just describing what the other person said.
Nice.
Yeah, no, I know, but
Okay,
so
nice. Thank you, Darlene. That's beautiful. Anything further?
No, I was
I
I
love
was
it.
just glad to finally getting closer to,
You're getting the
But
light bulb
I
moment.
think
Clarity.
watching
Good.
in person is a good thing.
It is getting in the courtroom and experiencing it all. So, Richard, what happens when you go into courtroom under Evidence Code 403? Why is 403 so significant, and what is it all about?
what we're doing tonight is we're going to talk about what is the significance of 403, California Evidence Code 403, and because
Oh, okay.
if you can, because, and this is David versus Goliath's regular Wednesday night meeting. Normally it's called Crab Meeting Night, but we're going to talk about California Evidence Code 403, and we're going to start breaking down the evidence codes and why they're significant inside the courtroom when you approach in the courtroom. See, California Ordinance Code, can you bring that up, Gavin? Can you bring it up so we can read it, so I can show the people, and we're gonna talk about that.
Yeah.
California Evidence Code 403. I want to pull that up so everybody gets to take a look at that. And then I'm gonna break it down. Hold on one second. Well, actually, we'll look at two. We're gonna look at 402. We're gonna look at California Evidence Code 402 and 403. Okay.
Okay.
We should also, yeah, we're gonna look at that, and then we're gonna raise a question, and that's why you should bring up California Evidence Code 402.
All right. Just a moment.
Mhm. Most of our problem is we as pro se litigants, or when we go inside the courtroom, we assume, like everybody else, we assume that all the elements are in place to go ahead and move forward, to have the matter adjudicated by your administrator, your judge there. And if you don't look at it and validate those things, they just move forward. Okay, so we're gonna look at California Evidence Code 402, and look what it says right here. Can you read that, Gavin?
All right. So California Evidence Code 402, with the existence of a preliminary, when the existence of a preliminary fact is disputed, its existence or non-existence shall be determined as provided in this article. The court may hear and determine the questions of the admissibility of evidence out of the presence of hearing of the jury. But in a criminal action, the court shall hear determine the questions of the admissibility of a confession or admission of the defendant out of the presence of the hearing of a jury, and if any party so requests. C, a ruling on the admissibility of evidence implies whatever finding of fact is prerequisite thereto. A separate and formal finding is unnecessary unless required by the statute.
Okay, so we'll hold those thoughts there, and you'll look at there. So where it talks in Exhibit A, when the existence of a preliminary fact is disputed, its existence or non-existence shall be determined. Okay, now let's take a look at California Evidence Code 403.
Okay, preliminary determinations of admissibility of evidence. The proponent of the pro-offered evidence has the burden of producing evidence as to the existence of the preliminary fact. And the pro-offered evidence is inadmissible unless the court finds that there is evidence sufficient to sustain a finding of the existence of the preliminary fact when, number one, the relevance of the pro-offered evidence depend on the existence of the preliminary fact. Two, the preliminary fact is the personal knowledge of the witness concerning the subject matter of his testimony. Three, the preliminary fact is the authenticity of a writing. Four, the pro-offered evidence is of a statement or other conduct of a particular person, and the preliminary fact is whether that person made the statement or so conducted himself.
So, what we really need to understand is when you look at the first thing, when it says the proponent, so I mean, it's the person, it's either the person, the alleged entity by the attorneys, by the attorney, or the defendant, either side. It could be the defendant, the pro person, the defendant, or the attorney is going to offer evidence before the court. And that evidence has the burden of producing evidence as to the existence of the preliminary fact. And then we have to understand, what is a preliminary fact? And I think we went through this many times before in the past. So if somebody brought a complaint against you and they say that Wells Fargo Bank has the right to do business in the state of California, that's considered a preliminary fact. That is not factual. It's only a preliminary fact. See? How do we know that it has a right or doesn't have the right to do business in the state of California? We just assume without an objection, it stands as facts and before the courtroom. When they say that Deutsche Bank purchased the property at a trustee sale, okay, and duly perfected its title, that's a preliminary fact. They're making a statement of a preliminary fact. It's not factual, but what they contend is that they put the trustee deed upon sale has been recorded as duly perfected title. That's their evidence to comply with their preliminary fact, their evidence for the preliminary fact. So the proponent, the plaintiff, let's look at the plaintiff from this side, the banksters. When they come before the courtroom, they're claiming that they have evidence sufficient to meet their preliminary fact to prove to the court that why they should have their day in court, why they should have the ruling in their favor. Now, what happens here is in this evidence code, it tells you as to the existence of the preliminary fact and that pro-offered evidence, and that evidence that's been offered is inadmissible. So now it's before the court, but now what you have to do is you have to stop and think. The burden now shifts to who? The court. Unless the court finds that there is evidence sufficient to sustain a finding of the existence of the preliminary fact. And most of us are in UD courtrooms, and it's a lot easier to do that because most of the time these people come forward here and they're bringing this action against us, an unlawful detainer, okay? And they're making all these allegations of, duly perfected title pursuant to 2924. Those are all preliminary facts, and they make a recording pursuant to 2924 HC, but they don't say that. They just said that they duly perfected title pursuant to 2924. And we just assume that that's what they mean. So now the judge has to look for the fact or to find an evidence sufficient to sustain their pro-offered evidence. So what can you do in this point? What are some of the things that you can do to the court? Because you're before the court and you can ask the court when you walk inside there, let's walk through a scenario. When you walk in there, you basically say, "Good morning, Your Honor. My name is so-and-so, and I'm the defendant in this matter." Okay. And you filed either a demur, motion to strike, motion reclassification, whatever. Okay. So you're the moving party. Because they filed their complaint, you're the moving party because you filed your demur, and you're going to be before them the first time. So you can ask the court, "Your Honor, I should be," after you've already checked yourself in, you don't have to object to the attorney yet. That can come. You don't have to object to him. You just asked if the court's being recorded. He's going to, "Yes, it is. Can I use that for reversible error on appeal?" "Yes, you may." "Are we going to swear in?" "Okay." You get sworn in and you stay there. Now you ask him, "Your Honor, before we begin, I got a question. Is it not, in accordance to California Evidence Code 403, is it not the burden of the plaintiff here to provide evidence sufficient to meet their preliminary fact? And then that evidence is inadmissible?" And the court will say, "Well, yeah, yes, it is, Matt." Yeah, but doesn't that burden shift now to the court to find evidence sufficient to sustain their preliminary fact? Evidence sufficient to be able to sustain their preliminary fact? Well, yeah. But if the court don't know, he says, "Well, I'm not really familiar on that." I said, "Well, I submitted a copy, the court to take judicial notice as Exhibit C, and you look there, there's an authenticated copy from the Secretary of State, legislation of it. I'd like to go over that with you." And then you read that into the record. Then what you do is you ask them, I said, now that we've gotten to this point and we can all concur that this is what the statute means and its interpretation of what it means. So let's move forward. And I'd like to ask the court a question. Can the court direct me to the evidence that the court is relying upon to meet plaintiff's preliminary facts? Now, at that point, the court's going to say the trustee deed upon sale. Okay. When the court says the trustee deed upon sale, because he has to, you look at number one, it says the relevance of the proffered evidence depends on the existence of the preliminary fact. Okay. The preliminary fact is that they bought it at a trustee sale and they duly perfected title. So now the court's going to say, well, the trustee deed upon sale. See, because that's the only, well, actually there's three elements within a non-lawful judicial foreclosure sale, which they must comply with. One is they either give a 3-day notice to quit, 3-day, 90-day notice to quit. They have to have that. Then they have to have proof of service of serving that 3-day notice to quit. And they have to have the trustee deed upon sale. Those are the three elements that they need to be able to comply with the non-judicial foreclosure pursuant to 1160 CCP 1161 AB3. That's all they've had to meet their requirements. But so what you want to do is you want to ask the court. I said, can the court direct me to the evidence? Okay, so when you do that, now the court has to direct you to the evidence, which means he's going to rely upon the trustee deed upon sale. Okay, now, when we look at the documents that have been presented before the courtroom, even if it's a certified copy, but a lot of the times they don't put a certified copy there. It's just the trustee deed upon sale. So at that point, you can object to that. And then you can object hearsay, lacks foundation. Okay. Is the court familiar with Herrera versus Deutsche Bank? Now we have to look at Herrera versus Deutsche Bank and see when that case was cited, when it was published, and find specific elements within that case law and then recite that case law to the court. Then also ask the court, is the court familiar with Fontenot versus Wells Fargo? Where in Fontenot, Your Honor, has said that absent the authentication of a document, absent the challenge of dispute to the authentication of a document, the court can take judicial notice of that document, but I'm challenging and disputing that. So therefore, it's going to fall underneath the hearsay rule. And therefore, also, to compound my objection, I'm going to say that at this point, is there anybody here that created the document? Anybody here that's signed the document? And anybody here that's notarized that document? And that's what you want to have on the record. Now, he just brought up Herrera, the decision on it was publicized back in when was that published?
2011.
Yeah, 2011. And in Herrera versus Deutsche Bank, they brought up, I can't remember if it was like 5 or 6 documents that they were moved to court to take judicial notice of. And the court said that they could not take judicial notice of those. They could take judicial notice of the legal effect of it being recorded. And this is another big problem I have. They said that they could take judicial notice of the parties to the contract. See, but see, when you record a trustee deed upon sale or any document, it's the county recorder's office doesn't authenticate any of the elements inside of a document. They don't authenticate the parties, whether it was bought by Deutsche Bank or US Bank, or if it was bought by a third party. They don't authenticate that. They don't authenticate that the amount of money that was paid. They don't say, well, yeah, that's the exact money that was paid on. They don't authenticate that. They don't authenticate the person that signed it as a trustee. Do you authenticate that this is a trustee sales offer? No, we don't. We don't get into that. And then do you authenticate that this person notarized this? No, we don't authenticate that. So see, for the longest time, everybody's been allowing these things to go forward in these courtrooms, and without authentication are challenging and rebutting these presumptions.
What's the holding here?
There, if you go down further, let's see.
This isn't the entire case. This is a summary you sent me.
Yeah, there's
You
another.
get the whole case? Okay.
Yeah, you need the whole case on, because it breaks it down. There's like 6 or 7 documents that they asked to take a look at, and even the trustee deed upon sale, and the court remanded the case. I mean, sent the case back down to be adjudicated, because they could not take judicial notice of those particular documents. Let's go through here. We can take a look at this. We go down a little bit further here. Right here, let's see what document that. Okay. We need to highlight though, because in here, where it talks about this, as matters may be judicially. Yeah.
Oh, matters being judicially noticed?
Yeah.
Matters that may be judicially noticed can support a motion for summary judgment, 437C. However, plaintiffs contend the trial court erred in taking judicial notice of the disputed facts within the record documents. We agree.
The judicial notice is the recognition.
Yeah, it's the recognition and acceptance of the court for the use of the trier of fact or by the court of the existence of a matter of law or fact that is relevant to an issue in the action without requiring formal proof of the matter.
So now let's stop there and see. I want you guys to understand, when you read this stuff, You find the key elements of what you're doing when you go before the courtroom.
So
It
it's
says-
defining what a judicial notice is right there, right?
Absolutely, but
A
the most,
judicial
one of the most
notice-
important, but you need to look at this. Judicial notice is the recognition and acceptance by the court for use by who?
Trier of fact, or the court.
So is he the trier of the case or trier of facts? He's the trier of facts.
Or the court. Well, which
Yes.
which one is it? It says trier of fact or the court.
Yes, it's the court, but the court's going to accept it because of the trier of facts. See? It's going to be because the court's going to look at the whole court's going to look at the entire
Oh,
case.
the trier of fact would be the jury. Got it.
Yeah. So see, but the thing is that by the trier of facts, it's not the trier of the case. See, he's not the trier of the case. He's the trier of facts. And you're going to read other case law that's going to talk the same way. He's a trier of facts, not the trier of the case. But what happens is we continue to allow them to be able to try the case through discovery, through adding other case law, asking discovery questions, things like that. But that's significant. You have to understand the trier of fact.
That
Okay.
is significant. So they're saying right there that that's very clear. The trier of fact, which would be the jury, or by the court would be the trier of fact.
The
So a good
existence of
question
the
would
matter
be-
of law.
Is this court the trier of fact or the trier of the case?
Absolutely. See, that's the thing is, and then what you're doing is when you raise an issue before the court, you have to make sure that you're on point. Okay. And
What about
that
this
you
part
have
here?
evidence, you have the evidence. See, one of the things
Taking-
that, yeah, you can read that one. Taking due notice of the document is not the same as accepting the truth of its content or accepting a particular interpretation of its meaning.
When
Okay.
the courts take judicial notice of public records, they do not take notice of the truth of the matter stated therein. When judicial notice is taken of the document, the truthfulness and proper interpretation of the documents are disputable. Store Media versus Superior Court. So the court considers the scope of judicial review of a recorded document in Poseidon Development. For the fact that the court can take judicial notice of a recorded document or similar document does not mean that it may take judicial notice of factual matters stated therein. For example, the first substitution or the deed of trust or the assignments.
Absolutely. See that for the first substitution recites the standard. Oh yeah, absolutely. See, and this is the problem that we have. We really, so you need to recite these cases. And I tell you that when you have your binders put together, you should have Herrera, you should have Fontenot. See, Fontenot versus Wells Fargo, that again, it says that absent the challenge to the authenticity of a document, the court can take judicial notice. See, if we don't do it, it tells us if we don't object, we don't challenge it, the court can take judicial. So it's on us to know this. These are simple little things that we need to know when we walk inside there so you can cite these cases. Okay. So when you're there before the court and this guy is trying to present evidence and facts before the court, you need to object because attorneys, okay, attorneys, when they become inside there and they verify the complaint, as we said before, when they verify the complaint, they step into the doo-doo shoes of a witness. They become a witness to the game and they can be examined, direct examined, cross-examined. They can be subpoenaed. They can be deposed. They can be stepped into all that stuff. And I'm telling you, if we really had the time, we really need to be able to get into doing that. We really need to get together and start formulating those thoughts and hammering these guys on that stuff because they do not have any firsthand personal knowledge. And therefore, the laws, the statutes are clear. If you have no firsthand personal knowledge, then you cannot testify. And if you submitted the document before the courtroom right now, as an attorney does, when he submits the complaint is the foundational document before the court. That's the controversy. That's the controversy before the court. When you respond to it, but now the court says, now we have a controversy before the courtroom. He says, now I can adjudicate this. No, not yet, because we've not established whether that complaint that's been before the courtroom has been verified or and filed by somebody that has firsthand personal knowledge of the matter. We just assume that the attorney's there, the complaint's there, your response there, the judge is there. Let's move forward. And that's what happens every single day. You don't hear this. You've only heard, I've had people in the past I've worked with and guided along, and then they go to court and all of a sudden somebody calls me and says, I just saw one of the guys that you were working with because they told me that you've been working with them. Totally different in the courtroom. Raising these things, objecting to this, challenging the judge on this. I've never seen that because you don't hear them challenge and dispute that. You don't hear them challenging and disputing to the attorney, objecting to the attorney. But see, these evidence codes are significant. Pull up California Evidence Code 1115 when we talk about the burden of proof, because under 403, it tells you the proponent has the burden of providing evidence sufficient to meet that. So let's look at California Evidence Code 115.
Okay, 115, just a moment here. Okay, 115. All right, division, burden of proof, 115. Meaning or means the obligation of a party to establish by evidence a requisite degree of belief concerning a fact in the mind of a trier of fact.
See where it says again? Who is it? It
Trier
doesn't
of
say the
fact.
donkey. Doesn't say the donkey up there. It doesn't say anybody else. It says the trier of fact. It doesn't say the trier of the case.
Or the court.
Yes.
The burden
Stop
of
it.
proof
Go ahead. Go ahead.
may require a party to raise a reasonable doubt concerning the existence or non-existence of a fact, or that he establish the existence or non-existence of a fact by a preponderance of the evidence by clear and convincing proof, or by proof beyond all reasonable doubt.
By all reasonable doubt. But see, in here we have our key words. These are things, what we talk about is the trier of facts. So let's start from the beginning. The burden of proof means the obligation of a party, whether it be the plaintiff or the defendant, either side, to establish by evidence. To establish by evidence. Okay. What's missing there? When it says established by evidence, what does it mean?
Testimony?
Admissible evidence.
Admissible evidence.
It doesn't mean just, see, you might say, okay, he provided evidence. Well, wonderful, that's great. It has to be admissible evidence. Is hearsay admissible evidence?
Well, if somebody passed away, a will could be something like that. If you don't object, I mean, but.
Yeah, if you don't object.
Oh.
If you don't object, remember, an objection not raised is an objection waived. So therefore, it's by admissible evidence. It doesn't mean by the attorney gets up and says, well, you don't have exhibit A, I want to enter that exhibit, as evidence there. And I have the trustee deed, I want to enter exhibit there. You don't
Let's
object, it's
go
going to
through
stand as
that.
fact.
Let's say I'm counsel and I say, hey, okay, Your Honor, I'm the moving party today. I move for summary judgment here, and the defendant here failed to pay his mortgage payments, and I've got my exhibit A, which is the trustee's deed upon sale. I'd like to move that into evidence, Your Honor. Here it
And
is.
at the
Your Honor.
first thing you want to do is you want to say
You're up. You're
objection.
defendant.
Yeah, you want to say objection, Your Honor. I'm going to object to the attorney continuously to testify in this court.
Hold on,
Under
defendant.
702, lack of
Let the
first-time
attorney
pers-
finish.
Well, okay, I'm going to hold my objection, Your Honor, until let him go ahead and continue. And then-
Yes, Your Honor, this is perfected from the county recorder's office. We got a certified copy right here, and it shows that my client, Wells Fargo Bank, duly perfected title. And he met all the recitals here, and take a look, and the defendant has a copy. I'd like to move that into evidence as exhibit A. Will the court take that in right now?
Objection, Your Honor. I'm going to object to the court taking it into evidence. Okay, under 421A
grounds?
be the evidence code, but I'm also going to object on Herrera versus Deutsche Bank. I'm also already objected to the attorney testifying before this court under 702, lack of first-hand personal knowledge. I'd like to ask the court a question. Is the court going to allow this gentleman over here who's failed to swear in under 710 to take his hearsay testimony to make your determination in this courtroom today? Now, the court at that point is going to look at you in three different ways. One is upset. I'm not here to give legal advice. I'm not here, I don't have to answer that. And he's, I move on with your other discussion or arguments that you want to make. Well,
Yeah, I'd like to make an argument as the attorney here for the plaintiff here, if I may, Your Honor.
But see, the thing is at this point, Your Honor, I said at this point, I'm going to object to him making any other statement. If he makes a statement, that I have no problem with that.
I'm gonna make a statement. And my
Okay,
statement is 2924. I want to talk about what it says. And in there, it creates a rebuttable presumption that gives the court the authority to take that trustee's deed upon sale in based upon viewing it as a certified document. The court can take that in as evidence.
and Your Honor, like he said, a rebuttable presumption, and I'm rebutting the presumption. Okay, at this point, I said the statute is not vague and ambiguous. It's very clear and defined. I said, but you can't just pick and choose what part of the statute that you want to use. If he's bringing an action pursuant to 1161A(b)(3) to this courtroom, it said that the property had to be sold in accordance to 2924 in all, meaning that you have to start with 2924A6. You have to be the holder of the beneficial interest before you can initiate a foreclosure. And if you do that, we have to comply with 2923.5. Okay, there has to be a declaration in compliance with 2924.17 and CCP 2015.5. And I have those statutes here, and I'd like to go through those individually, Your Honor, to make more clarity so that the court can understand and see where I'm going with this argument.
Well, can I jump in, Your Honor? Yeah, I think the defendant here is well intended, but as this court's well aware, this is a limited jurisdiction court. And as the court is aware, it doesn't have the jurisdiction to try complex issues of title like the defendant is attempting to bring up today. So,
Well, Your Honor, once again, I'm going to raise a strong objection. I'm very familiar with the summary nature of this courtroom. It's a limited courtroom dealing with real properties and deeds of trust. Okay, now there's two issues before the court that you have to look at. One is if it's a landlord tenant issue under 1161 CCP 1161, or if it's a homeowner purchase under 1161A(b)(3. Now we have significant case law here to begin with that supports my contention that they failed to comply with certain the strict mandatory statutes requirements. See, that has been implemented by legislation and confirmed by our Supreme Court case in Dr. Lever versus Westlake, Kessler versus Bridge, Preciado versus the Bank of New York Mellon. And there's several other cases, Your Honor, which I can cite. I have them right here, and I need to open up my binder and I'll cite the cases. I'll cite them exactly as they are. So it's not that I fully understand this, but I'm going to object to him testing it further right now. And he's failed to comply with the statutory requirements, bringing this action before this courtroom, and I can show the court.
And Your Honor, I'd like to just ask the court, has the defendant presented any evidence to rebut my trustee's deed upon sale that my client delivered effective title? Has he brought anything to this courtroom today?
Yes, I have, Your Honor. I've already submitted it. I've moved the court to take judicial notice of the documents already. And that's what I was going to get into. If
Richard,
I'm going to continue to object to him unless he's proven that he's.
Sorry, Richard, which court are you guys talking about? I'm totally lost. Are we talking
about every court? See,
Every court,
any court you go to, I don't care what it is, when you get inside there, it can be a UD or it can be a civil unlimited case, it can be a criminal case. See, whatever they're going to do, whoever's testifying, like the attorney, he doesn't have a right to testify. No attorney has a right to testify in the courtroom. And you can object to rebut to him everything he states before the court. If the principal's not there before the courtroom, if you have the attorney, but you don't have the principal with them, all the court's going to hear is hearsay. Everything he relies upon, if he's talking about you, your payments, your history, all that stuff, that's inadmissible hearsay. If he's giving a statement saying, like Gavin had just raised right now, he raised an issue about 2924. He's making a statement on an issue. You can object to that still because.
Well, I want to say to the court, Your Honor, I failed to get any evidence from the defendant. He's talking about our evidence. We brought our evidence to the court. What did the defendant bring?
Objection, Your Honor. I said, who brought the evidence before the courtroom? I'd like to, at this point, I'd like to call the attorney as a witness before the courtroom, Your Honor. And see, that's what's going to happen. The court's going to say, well, no, we're not going to have any of that. There's not evidence here and da, 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 da. They're going to say a lot of this stuff, and you need to be prepared and ready on how to respond to them on that issue.
Right.
Okay,
Can I ask you real quick? Sorry, I was real quick. If there's no court reporter from the beginning, we don't even continue.
Then
right?
you might as well just go and stay home. It's
Exactly.
like talking to the woods up in the mountain by yourself. Who's going to hear you?
You'll see like Darlene's hearing today. That's a great example. 4-letter words going back and forth throughout the courtroom. That's a typical no court reporter here.
Yeah. They didn't. I'm sorry to interrupt you. They had no court reporter at my hearing. They said I have to bring one. I said, what?
Oh yeah, what happened with your hearing, buddy? Tell us.
So they
about your
went.
hearing.
They went with a tentative ruling. So that was good. So they denied the motion. They actually he actually went ahead and he said, the judge said, he said, I don't like the way that you're proceeding to the referee's counsel.
Well, take us back to the beginning. So you go into court and,
Right.
you called the case. Were you
Right.
represented by an attorney or were you pro
Right.
se?
So that's the thing. So I on record, I'm with an attorney. So they were like kind of like pushing me around,
So you go
and-
into the court and they said, all right, defendant, is the attorney here? What happened?
No, I'm not even the defendant. You see, I was nobody. I was just they call me they call me a petitioner. It was very weird.
Right.
And there's a defendant, there's a plaintiff, there's a defendant, there's a petitioner, there's a non-party. The non-party is the referee, and the referee is bringing action against the petitioner. The whole thing's all messed up and all confusing.
see,
And then
Let me, before you get too much into that,
Yeah,
I'm gonna
but
show you
we
something.
just want to
right
find
now.
out what happened as well.
Yeah,
So
wait
you-
a second. I'm gonna show you something because you guys need to hear all this stuff real quick, like right here. See, when they called you a petitioner, I would have said, Your Honor, do you have a copy of my grant deed or you have a copy of my trust? You have a copy of whatever was been given to me I'm not a petitioner. I'm an
Yeah.
owner.
I
I'm
went
the
even
owner
better
of
with
the
that.
property.
I went even better than that. I said, Your Honor, on September 30th, 2021, this court has made it aware that not only that I'm not just an heir, I'm also a party to the case. And I was in the first amended complaint was I was named, and I said that. He goes, I don't want to. I understand what you're saying, but I don't want to talk about that. You didn't want to get involved in that. Like, I understand what you're saying, but it's not what's on the hearing today, because he knew what I was talking about, because I'm a party to the case.
What about the
Yes.
attorney? Did he want to argue the merits?
No, the attorney didn't speak. He has withdrawal on the 26th. It's the whole thing's a
Oh,
mess.
no, I'm sorry. The moving party's attorney. The
Oh,
moving
yeah.
party. What did he want to argue the merits?
Oh yeah, he wanted to argue the whole thing, and I kept on objecting, and they silenced me over and over. I'm like, there's no record. I said, there's no recorder here, and what's going on? I started with that, but it wasn't.
Of course
I
not.
didn't
So
want
they
to push-
were, because there was no court reporter, was it a fair hearing?
I mean, in terms of fair, yeah. I mean, everything that they said was not recorded, so it didn't really matter what they were saying, right? So
Exactly.
At the end of the day, it
Blowing
was
in
like,
the
whatever.
wind.
Right. So at the end of the day, I had to be quiet as much as I could, so I didn't want to piss off
Were
the
there
judge.
any four-letter words like Darlene's hearing?
Well, there was, the judge did say something about due process. He said, you have to take this to a UD court, and he said, I'm not a UD judge, or this court is not a UD court. You have to go to that court. And then the petitioner, the counsel of the referee said, well, can I just have an extension of time so we can bring him back here, and I'll show you how it's important to do the civil court. And he's like, well, I suggest you go to the UD court. And that was it. He denied the motion. That was it. So it's good news.
Nice. Good
Yeah, it's
job.
good news.
Way to
Yeah,
go.
I didn't do anything.
Way to
really.
go.
Let me
Okay,
ask
you
you this. Let me ask you this. Okay, so when you went inside there and you objected because there was no attorney, did they say anything when you said that there's no court reporter?
Yeah. I said, is there no court reporter? No recording. He said to me, well, you have to bring one. I was like, oh, well, I actually put in, I put in a
You
paperwork
requested
to,
one?
say again?
So you
Yeah,
did-
I requested one. Yeah, I requested one. Yeah, and I requested one, but my paperwork is not going through.
Okay.
And he goes,
Okay.
well, I don't see anything on the record, and I don't see anything on the, that kind of stuff. And
Okay, so they didn't get your
yeah.
request.
Okay, hold
they
on one
didn't get any
second.
of my
Wait,
paperwork.
wait.
They didn't get actually. Sorry, they actually didn't get any of my paperwork apparently, because he said he didn't get anything, and I've been rejected 5 times already. So it's like it's a mess.
Okay, so an
Okay, but let me
administrative thing.
explain how you can get around that, what you need to understand,
Okay.
okay? Because what you did you file it with the court though?
No, he said his paperwork
I
never got
didn't
filed.
file it. I submitted it. I didn't.
How did you
tried to-
submit it?
Say again.
How
I
did-
submitted it when?
Yeah,
Oh, I submitted it maybe last week 3 times, and then yesterday.
Was it
twice.
online?
Yes, it was online. Yeah.
Okay, that's what he's
Okay,
saying.
but-
When you
but-
go
but was
online,
it-
they might
but-
reject it.
do you have a record of
did.
it being accepted or not accepted?
When you say
No,
accepted, I
It was
rejected.
all rejected, he said.
I have one accepted, and that's the fee waiver was accepted, and then it was later on rejected, and I guess after, I don't know.
Then
or
you should have
denied.
brought that into the courtroom. And there's case law supporting that when the clerks or somebody denies that
Oh,
it's
yeah.
been accepted. But then they have to give you notice of the deficiencies inside that, and they can go ahead and present it.
They
But the
should, they
thing
should,
is,
they should, I'm sorry, they should actually.
wait a
file it
second,
with the
wait a
court.
second,
do
I'm
a
gonna
lot of
explain,
things.
wait a second,
Okay.
John. Okay, you guys talking too much. Stop
Let's
that.
mute out,
for
John.
a
I'm gonna come
second.
back to
What
you,
I want to
okay?
understand is this, that the thing is that when you file that into the courtroom like that, or you filed it in the deal, it's already accepted, and there's case law to support that. Then what you do is you bring those documents into the court, and if he says, I don't have it, I have a copy that was accepted right here, Your Honor, and I'd like to submit that to you. That's what you do. Okay?
Okay.
You guys got to stop talking around all this stuff. You guys got to get to the specifics and understand what you need to do. Because if you do something and it doesn't get done correctly, because I've had to deal with this last week. I got some people that wouldn't accept their paperwork, and then I chastised the clerks and then filed the case law in there, and then they took it, and then the court granted them what they wanted to do after that. But we have to be very specific on what we're doing here. So if you file something and it gets filed, that's the reason why I was asking that. If it got rejected, then you take it back into them. They rejected it because I attempted to file it and the clerks stopped me from doing that. Okay, here's the case law that supports my contention that it should have been filed at that point. But so you're still filing by yourself as a pro se litigant. So there's a lot that you still need to learn as you move forward on this issue. Okay.
I
There's a lot.
understand. Yeah, I understand.
But there were certain things that I wanted to ask you so that we can find out for the rest of the people, and then I can show you and how to work through that as you go along. The main thing was you were there for only one issue and one issue only. And that Gavin was very clear on that last week when we were talking, remember? He said, you don't need to talk about a lot of things. You're only there for that one specific issue and stand on the tentative.
And they stood on the tentative. That was it. Yep.
Yeah. Wonderful.
That feels good, doesn't it?
Yes, it's nice. You know, it's very nice. I was just, you know, I just didn't understand, of course, why they didn't allow it. And my head is thinking maybe because I had an attorney and the attorney's hearing for the withdrawal. Yeah.
Here's the good news. That is over with now.
Oh,
They
yeah,
might
thank God.
appeal, but you don't have to deal with or wonder all that stuff. It was a really
Oh, my
screwed
God,
up
yeah.
case to the beginning, it sounds like. But the judge
Yeah.
obviously, he said it's all over with.
See for them, but them to move forward with what they're doing because they have to take him to unlawful tender case. He still needs to interplead himself into that case to stop them
No,
from
that,
doing what they're
well,
doing.
maybe, but I think that case is over with because they wanted to kick everybody out. And if they want to do that, they're gonna serve a notice to quit.
Well,
next.
see, the thing is they wanted the right to be able to go and sell the property and to be able to do all those other things. So anyway, we'll talk about that later.
Yeah, we could go into that later. It's really complex, but you know, I would say if regarding the UD stuff, if you're going to be facing a UD, you want to be aware that if you see a big giant guy
Sticker.
outside of your property with a big old, you know, black sign, he's like looking for people, he's eating popcorn and spilling, you know, coffee on the floor, that would be a process server. So watch out for that guy. And I would expect to see him tomorrow. That's usually, if they're aggressive, that's how they'll do it. He comes in, he's
Well, you know,
real loud.
They had a guy come around today, and they were posting you know, flyers on people's on units, you know, that they want to take possession of those units. And
Well,
the storage rooms.
well, flyers are different. They do what's called a notice to quit, and that's they post that on somebody's door usually. Yeah, so you want to be aware of those type of things and be mindful and don't treat them as junk mail. You know, you gotta read them carefully. Okay.
But what you want to do also, how many units is there?
16.
Okay, and are those people, are they interested in staying there for quite some time?
They have stayed there for a while. Yeah.
No, but yeah, but see what you need to do. You need to you need to group together and sit down, and there's some things that need to be done.
Well, I'll tell you, I thought I had people with me in the and in the beginning they were paying me, but then they kind of threatened them to take them to, you know, to court and stuff like that and sue them. So I lost a couple left. A couple of them moved out. A couple of them are paying them now. So, you know, I lost maybe you know, my contracts, I guess, in a sense. You know, I lost all those contracts.
Well, what you do is, I'm going to tell you what you do.
Tenants.
You go to get that minute, but it would have been better if you had a recording. But you get that tentative ruling, and you get whatever the minute order that the judge writes, and you could have asked. Well, you couldn't ask for a statement of decision because it didn't go long enough. But the thing is that I would get that information. With that information, there's certain things that you can do. You can go and talk, you know, to build
Yeah, in the next
collaborate with
court.
these guys and move forward.
Yep.
Yeah.
Exactly.
Is there any comments or questions? We're talking about California Evidence Code 402 and 403 and Evidence Code 115. Any comments? Any questions?
Well, Evidence Code 115 is significant. I will just comment on it because doesn't it raise
The
when
bar.
you bring up, Yeah, once you bring up 115, doesn't it raise the bar up a little bit, like on,
Beyond all reasonable doubt, beyond
yeah,
all
and
reasonable doubt.
isn't that word also found in another important case?
Yes.
Beyond reasonable doubt, is that Dr. Legal? Or is
Uh,
that Kessler?
no, that's Kessler versus Bridge. I mean, Kessler versus Bridge and also, Preciado.
Now, beyond, so I guess in simple terms, everybody's probably familiar with in criminal court, like if you're gonna be tried as a criminal, don't they have to have all proof beyond all reasonable doubt?
And they're supposed to,
Okay, we're supposed to.
they're supposed to.
So, but in civil court, it's not always that same standard. Is that
It's
correct?
because we don't raise the bar like that to them. We don't challenge and dispute that because we're not going in there correctly to be able to do certain things.
So they can, because we haven't raised the standard up through the proper objection, then are you saying that it has a lower standard? But we
And you
can
can put
raise
that
the
in your
standard.
paperwork, though. You can put that in your paperwork under California Evidence Code 115.
And
See,
where
when
would
you put that-
where's the one page per paper that goes if you're a defendant?
You
Yes.
can do it in one of your cause of
When you're-
action. They failed to meet.
Oh,
their
well, if you're the
burden.
plaintiff, yeah, but
Yeah.
I'm saying if you're the defendant, it goes where? One place. The answer.
Pardon, real quick, was that Prashad? What was the other case again? I forgot. I'm sorry.
Oh, Kessler
Thank you.
versus
That's
Rich.
right. Thank you. I yield.
Is there any other questions concerning those issues? You know, because when you're going before the courtroom, again, we always walk into the court on an assumption. Remember the assumption, we need to be able to challenge everything. See, as I told you before, I was before the court and the attorney kept walking in there and he was trying to make statements and testimony, and I objected. I objected, testified, and stated he was not a party to the action. He was not a part of the action. So therefore, you believe and assume that these attorneys that come before this courtroom are the party of the action. So if you walk in there and he's a special appearance attorney, what do you do? What do you do
Object.
if
Is
he's a
this-
special appearance attorney?
Is this the attorney of record or the special appearance attorney, Your Honor?
Absolutely. The court's going to say he's the attorney, he's a special appearance attorney.
Has he filed his paperwork with the court?
On what? What are you talking about?
Has this attorney filed his paperwork with the court under 284, 283, 284, 285 of the California Civil Code of Procedure?
Like a notice of appearance?
Hold on, let's mute for a moment,
Yeah.
okay? We're gonna
Well, yeah,
hold
so-
all your questions. And unless there's any questions, go ahead, but if everybody start talking at once, it
But,
gets.
but can you explain what that means of those codes that you're reading out?
Okay, yeah. Okay, so, well, I was asking, so he was kind of role playing with me, right? What was your question? He's saying, okay, Richard, what did you ask?
Well, see, in other words, what I said was, are you a special appearance attorney or the attorney of record?
Oh, yeah, right. And I said, well, did the attorney file his paperwork with the court?
Yeah.
If he's by special appearance?
See, they have statutes almost for everything. For an attorney, that when an attorney comes before the courtroom, he's supposed to give notice to the court and you under 283. If he's a special appearance attorney, if he's changed by another attorney, then he has to file a Civ 150 as a special appearance attorney, and he has to give notice to you and the court. See, we have a special appearance attorney that represents us all the time, so he has to file a Civ 150. It's called a special appearance attorney. In fact, you should pull that up, and they're required to be able to do that.
Well, the Civ 150 is what's the difference between a limited scope attorney and a special appearance attorney?
Same thing. He's a limited scope. And if he has to come there even as a special appearance attorney, he has to give notice to you stating that he's going to he's not representing him the entire time. He's only there to make that day, that appearance for that day, or maybe another time. But what they did is they have like their own kind of like little rule, but under California Code of Civil Procedures 284, it's specific. Notice of limited scope representation. And it's the same thing with a special appearance attorney. Are you going to, you can ask them, are you coming on here under a limited scope? Are you going to be an attorney of record? Are you going to? And what's going to happen is they're going to, you can ask them, the judge might say this, while he works for the attorney law firm, or I work for the attorney law firm. And you're going to find out that they don't work for them. They're not employed by them. They don't receive payroll checks. They get paid underneath the table.
Yeah,
So,
wow.
Under 284, it tells you they have to give notice to you of their agreement signed by the original plaintiff and the attorney of record, allowing them to present themselves before that court.
Okay, so let's say that I walk into court and, Sam Chandler's on the other side and he's got a special appearance attorney that he pulled out from the hallway, right? I walk in, I say, hey, Your Honor, I don't recognize the attorney here. Is he the attorney of record or is he the special appearance attorney? The court says, oh, let me see. Well, counsel? Oh, Your Honor. Oh, I'm employed by the attorney of record at the law firm. Oh, so he says, oh, you are? I said, I object to that, Your Honor. Can I ask him a couple questions? Would you mind if you swear him in for just a moment?
Now, direct your questions to the court.
Well, I have a couple questions for the court. Has he provided the court any proof to show that he works as he is employed by that law firm?
He's not required to. He took an oath when he took the state bar license.
Nice.
The state bar? Is this
Yeah.
a state bar court? Is
No,
this a state bar court? Your Honor?
Continue with your arguments.
Well, I'm just trying to find out a little bit what type of rules this court abides by. Does this court abide by the California best evidence rule and the California rules of civil procedure?
Maybe I do and maybe I don't.
Well, how am I supposed to proceed if will the court, can I at least tell me, does the court abide by the California
They got a self-help court downstairs if you need any help with your legal advice.
legal advice?
Yeah.
Can the court give me some legal advice?
Well, no, I'm just saying that if you need some legal advice to be able to help you with your arguments today, you can go to a self-help court.
Will the court take judicial notice of California Civil Code 284 and 285?
Okay.
Civil Code of Procedure. Okay, yes or okay? Is that a yes?
Yes, we can.
All right, I'd like to direct the court to that statute there. It says there that when the attorney is substituted out for another attorney, they're required to give notice. So my question is did this attorney give notice that he's going to be filling in for Sam Chandra?
He did in his paperwork when he filed it with the court.
Oh, can I get a copy of that?
So you can get a FOIA request if you want to.
FOIA? Well, I haven't seen that, so I'm going to object to the proceedings moving forward. Is this so? I'm going to object to the attorney coming in and representing. I'm going to object to the proceedings moving forward. I'm going to ask this court to continue this case until they come correctly. Stay this matter until they come correctly.
See,
And that's it.
yeah, see
What
what
do you
you're,
mean?
have
It's
a
a
nice
notice of
day.
appearance, right? The notice of appearance you're asking for, correct? You're asking for a notice of appearance, right?
yes. See,
Okay.
under 284, they have to give a notice of appearance to you. If they don't give that to you, then you can only recognize the other party on the other side. The statute's not vague and ambiguous, Your Honor. I said at that point, I said, and if the court's not going to abide by the rules, I need to know which rules that you're not going to abide by because you're going to prejudice me, you're going to harm me, and you're going to financially hurt me. And if you don't want to answer that, then I'm going to ask you to recuse yourself. It has to get down to that. See, the thing is that we need to be prepared when we walk inside those court, if it gets down to that. See, because at this point, people are saying, oh, that's too aggressive to get to him right now. That you're going to make him angry and he's going to rule against you. Pull up their judicial canons 1, 2, and 3 if you can, Gavin.
While you pull that up, Gavin, I just want to let you know that I put the minute order in the chat room, just if anybody wants to look at it.
Okay. The thing is that we're going before the court and we're not properly prepared. We have to understand that we have rights.
The
These-
US
they're not-
canons,
Huh?
are they California or?
California judicial canons, yeah.
Oh,
Judges.
I'm
the
sorry.
judges-
I'm sorry, go ahead.
Huh?
I'm
hold
sorry.
your questions, raise your hand. We've got to have kind of an order here, so
Yeah.
it gets
Right, right.
chaotic when
right, I thought you were
we keep objecting. Hold on, hold mute,
Right,
please, JD. I'm
Okay.
saying, raise your hand and let's.
Okay, no
let's
problem,
just-
no problem, no problem.
All
I'll do
right.
that. Thanks.
Okay, so we got cannons are here. We got canon, is this the one?
Yeah, read 1, 2, and 3.
A judge shall uphold the integrity and independence of the judiciary. A judge shall avoid impropriety and the appearance of impropriety in all the judge's activities.
And 3.
a judge shall perform the duties of a judicial office impartially, competently, and diligently.
See, and these are the things that you have to understand as a judge when he begins to be upset and begins to show impartiality or shows aggression or shows a demeanor other than being impartial, it's time to recuse him. Because at that point, I'm led to believe that I will not get a fair and impartial hearing. Why? Because I'm led to believe that you will rule on your emotion, the emotional state that you're in, and not the rule of law. You see, a lot of people don't want to get to that point because they don't want, because they figured, well, and it's okay. You can go along in a sort of diplomatic way, using the court etiquette inside the courtroom and get what you want. Just use the rules, regulations, and you can be politely objecting and stuff. You don't have to get aggressive. It's only when you cite case law and you cite statutes and things like that, and he continuously rules against you. Boom, 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 boom.
Okay,
Yeah.
JD has a question. Go ahead, JD.
Okay.
I have to lower my hand on you. Thank you very
There
much.
you go.
So if you are in court and you mentioned this before, a little bit about the Zoom call, if you're in court, and they're all in Zoom and like you can't really see them and you can't really, you know what I'm saying? How do you kind of get that angle and say, like, you got to show up to court? I mean, like, how do you force them to come down? Or all the
Who?
lawyers are on
The first
online
who
or
to come down.
the other attorneys that are speaking the whole thing,
You
the
don't
other side.
need to. You don't need to. You can object to them when they're speaking on the Zoom. You can object to them when they're talking over the speakers over the deal. I did. It makes
Yeah.
no difference. I said, you stated your name for the record. I said, you the attorney of record or the special appearance attorney? It's easy. You just ask questions. And so then I said, okay, well, if you're the special appearance attorney, I said, did you file your notice? Because I haven't received the notice. So at this point, I can't recognize you. I can recognize the attorney of record who was, and I have their name right here, and I'm citing that. And he said, well, okay, well, if the judge, overruled this, that, and the other, you have to listen to that. Then you're going to find out what you need to say when he objects or challenges or overrules or denies or sustains, whatever. You have to know those terminologies.
So yeah, so you said the notice of appearance. How about a notice of a Zoom appearance? Do you need that as well?
Same thing.
Same. They have to give you a notice of Zoom appearance, right?
Okay, that's like me, JD. I'm representing you. I go to the court. I said I made an appearance for JD. Okay,
Yeah.
that's not sufficient yet. You had another attorney. I said I have to give a written agreement by you for me to represent you in that court and by the other attorney that you had before. It has to be filed with the court or given me a notice.
Okay, and then if they want to appear in Zoom, just if they want to appear the other side, do they have?
I
to
have
tell
no
the court?
problem with that. Let them appear. Okay, they're there. I said, did you file this complaint with this court? Yeah. Is that your signature on there? Well, I can't see it. Well, you should have been here before the courtroom. Yeah.
Okay.
If someone wants to appear remotely now, whether or not they honor this rule or not, it's 367.75 and then 3.672.
Thank you.
Notice of remote appearance.
See, there's a
So-
lot of things that have changed, but what happens is when
That's a new form.
what happens is they weaponize the system to deny us a lot of access to the court. And when you're on Zoom and you start bleep, anybody hear him anymore? No.
Well, one of the things
He
is
must
that,
have got disconnected.
and we,
Here you are. I'm here. I'm right
we've
here. I'm
seen,
right here. Can't you hear my? It looks
I
like
saw-
somebody's yelling in the background here, but we can't hear him.
I saw they did this to Bonnie before where she was remotely, she was traveling, she couldn't go in person, and then she was
Mhm.
trying to do it remotely and they blocked them, they wouldn't let her in.
Yeah.
And they wouldn't let her appear remotely. Then she waited for 2 or 3 hours and they said, oh, I don't think they got here. Or maybe they heard at the very end. Oh, no, they wouldn't let her in. She failed to appear. Because she didn't do
Absolutely.
this.
See, that's the problem that we have right now to begin
The other
with.
side was on the Zoom, Sam Chandra, he was allowed to.
Oh, yeah.
Yeah.
But see, this is what I'm talking about, guys. I said, we really need to understand our game when we walk inside the courtroom. And a lot of time we don't know, and it's okay. We just need to ask certain questions. This is what our David versus Goliath was to build gladiators, to be able to go ahead and foot soldiers, to be able to go ahead and go before these courtrooms, because we have more power than they do. Okay. When we walk into the courtroom, we're the only one that can testify. When you stop and think about it, you guys really need to stop and think about this. I walk in the courtroom, I swear in, they don't. Whose testimony can they take as truth and fact before the courtroom? Mine. But you don't know that, so you just talk anyway, but you don't ask the court certain questions. You have to ask the court questions, because if this person over here on the side, whether it's a special appearance attorney or attorney of record, they never swear in. Never. So any testimony they make is hearsay. Inadmissible hearsay. So when the judge makes his determination, what's he making on? Somebody filed a piece of paper that has been verified by an attorney.
I want
Wow.
to just, while I have it on the screen, let me just share something. It's a little bit off point, but I might as well just share it. This is probably one of the most valuable pieces of information I ever got in the last 5 years. And that was from Ron Cupp. We went down to
Who's that?
this guy, this ex guy, Ron Cupp. He's one of those,
Ex offender?
Yeah, exactly.
Ex-offender?
Yeah, Ron and I went we went on a trip actually, right when the pandemic started. I remember it started and they said, oh, everyone's going to get sick. So, don't do anything. Don't go anywhere. Ron and I like, let's go. We don't care. We're on a flight, and everybody else stayed home. And so we get down there and we're traveling and explaining this to me about this Casey. And I'm like, Casey, what are you talking about? Casey, you got to use this Casey for everything in your referencing. I'm like, oh my gosh, I never heard of it. So, it's like the Bible that the court relies on for most everything. And it's not talked about, I don't think, enough. But Judicial Council of California, Civil Jury Instructions, Casey, pronounced Casey.
Absolutely.
And so, if there's a question that you're like, oh, I wonder, what's about this thing or whatever, this subject. When you can see 3606, that's 3,000 pages, over 3,000 pages, huge. It's massive.
Yeah, it is.
So, but you just click on this and you search F wrongful foreclosure. There it is.
No, you didn't bring it up. You got the other one still up in front of us here.
Oh, okay. Let me go to that one.
Now put the other one up.
Okay.
See what Gavin's talking about is jury instructions. And let me tell you, this Casey, the one that he's talking about, has a lot of cases and information that you can refer to in here.
Right. This is so valuable. Everybody should keep a copy of this. So 4920, wrongful foreclosure, essential factual elements. So as an example, it gives an example as to what the elements are required to use. And at the end of the day, that's all that matters, right? Is the elements.
Mm-hmm.
And so every type of civil, most every type is in here. So at the very end, I think it was
Open it
47.
bigger. Open it bigger.
Okay.
Right there. Down back one, right there.
47. Here we go. It takes so long to load. It actually took, there it is. Wrongful, so it takes a minute to load because it's so big. Wrongful foreclosure essential elements. Plaintiff claims the defendant wrongfully foreclosed on plaintiff's house. In order to prove all these elements, the plaintiff must prove the following: that the defendant caused the foreclosure. Name of plaintiff. Under a power of sale under a mortgage deed of trust. That the sale was wrongful because, specify the reason. Fraud, willful oppression. That plaintiff tendered all amounts were due under the loan.
Or was excused.
Or was excused from tender because of whatever reason. That the plaintiff was not material in breach of any other condition and had not failed to perform any other material requirement of the loan agreement that would justify the foreclosure. That the plaintiff was harmed and the defendant's actions were the cause of the harm. Those 6 things got to be alleged. That's the elements. So every single thing that's before the court has a specific element process. Once someone understands the elements of law, you just learned more than you'll learn in 4 years of law school. basic, and I haven't gone. So
Everything's
but that-
here. In those cases, you can look them up and read them. You should always, when you find a good case and you look at it, read it. Read why they put it there. Pick it up so it's embedded in your mind.
Look at this. So any of these are just references of all these cases, 2924C, tender. So it's just, this is going through what are called the holdings. This is free. This document's free. You don't need to buy a Westlaw for this. Nothing. Just on the internet. I'll share it in the chat.
There
But
you
it has
go.
all the holding cases right here. These are the controlling cases.
Absolutely.
Current law, 2022 at least.
Yep.
Yeah, so everybody, I'll just post it there. Just, I had it on the screen. I use that. I always reference that, so it's good to have that. Thanks, Ron Cup even taught me something. Now, Ron, you can learn a lot from Ron Cup.
The sex offender.
Well, I think he's
So that's why you're hanging around with him. You're like Epstein or whatever his name is. You kind of look like him.
Yeah. So, yeah, that's the Casey jury instructions. So I got a complaint back. I got an answer back today. High level answer from a defendant. Okay, this is like a really amazing. This is actually, they did a good job. The attorney sued the defendant for declaratory relief. 1060. One cause of action. Simple. But the cause of action was brought under 2924M, which says that they've got to meet the elements,
Yes.
which says that if you're a owner of the property or a tenant in the property, you have the right to bid on the property at the sale. And your bid should be heard first if you meet these procedures. And then you can bring your bid in, match the bid, and you get the property. You could take it from the guy at the auction, the investor. You take it from him. Basically, you steal it from him. I mean, it's legal. So we're saying the complaint was, we want the court to declare that this investor wrongfully got a hold of the property. When this tenant put his money up, had his check, gave it to him, and the title company rejected it. We want the court to declare that it was wrong, there's a controversy, and that the trustee's deed upon sale should go back, and then the property should be transferred into his name. So that's so many things about it, but just one simple cause of action. But there is no private right of action for that thing. So that's really the only thing you could bring it under, 1060. So they answered. And 31 affirmative defenses, and they had fatal flaws on their answer. So one of the things they mentioned on an answer is if you deny something, if you don't specifically deny something, because you don't have enough information, you have to still give your belief. That's a particular of the cases. So when you read an answer and it says, I don't have enough information about this subject to form an opinion, so I'll go ahead and deny it. Is that pursuant to the authorities? That's not proper, and that defaults into an admission. That's now admitted for all purposes. So you can mark A. And Rick Schramm actually did the best on going through answers. So when you get an answer, you go through this process where you look at the complaint, you look at the answer, and then you color code it. And you take your complaint and then you mark on the complaint, okay, what was this? A for answer. Okay, D for deny. D for deny. This was admitted for all purposes because he didn't properly deny it. He didn't put his belief in there. The attorney screwed up. A, that's an A. So you start to go through your complaint, you color code it out to see exactly what happened. In this case, we've got a lot of A's. And then 31 affirmative defenses. But are affirmative defenses proper without facts? I don't think so. I think we read through that before, right? Yeah, so anyways, that happened today. It's pretty exciting. I want to see how that plays out. And if there's any comments or questions, or we can move to close early, or any cases? I know Bonnie on here, she is, let's see. Why don't we do this?